Chapter 5. Asset Recovery. Article 51. General Provision. The return of assets pursuant to this chapter is a fundamental principle of this convention, and states parties shall afford one another the widest measure of cooperation and assistance in this regard. Article 52. Prevention and detection of transfers of proceeds of crime. 1. Without prejudice to Article 14 of this convention, each state party shall take such measures as may be necessary, in accordance with its domestic law, to require financial institutions within its jurisdiction to verify the identity of customers, to take reasonable steps to determine the identity of beneficial owners of funds deposited into high-value accounts, and to conduct enhanced scrutiny of accounts sought or maintained by or on behalf of individuals who are, or have been, entrusted with prominent public functions and their family members and close associates. Such enhanced scrutiny shall be reasonably designed to detect suspicious transactions for the purpose of reporting to competent authorities, and should not be so construed as to discourage or prohibit financial institutions from doing business with any legitimate customer. 2. In order to facilitate implementation of the measures provided for in paragraph 1 of this article, each state party, in accordance with its domestic law and inspired by relevant initiatives of regional, interregional and multilateral organizations against money laundering, shall a. Issue advisories regarding the types of natural or legal person to whose accounts financial institutions within its jurisdiction will be expected to apply enhanced scrutiny, the types of accounts and transactions to which to pay particular attention, and appropriate account opening, maintenance and record-keeping measures to take concerning such accounts, and b. where appropriate, notify financial institutions within its jurisdiction, at the request of another state party or on its own initiative, of the identity of particular natural or legal persons to whose accounts such institutions will be expected to apply enhanced scrutiny, in addition to those whom the financial institutions may otherwise identify. 3. In the context of paragraph 2a of this article, each state party shall implement measures to ensure that its financial institutions maintain adequate records, over an appropriate period of time, of accounts and transactions involving the persons mentioned in paragraph 1 of this article, which should, as a minimum, contain information relating to the identity of the customer as far as possible, of the beneficial owner. 4. With the aim of preventing and detecting transfers of proceeds of offenses established in accordance with this convention, each state party shall implement appropriate and effective measures to prevent, with the help of its regulatory and oversight bodies, the establishment of banks that have no physical presence and that are not affiliated with a regulated financial group. Moreover, states parties may consider requiring their financial institutions to refuse to enter into or continue a correspondent banking relationship with such institutions and to guard against establishing relations with foreign financial institutions that permit their accounts to be used by banks that have no physical presence and that are not affiliated with a regulated financial group. Each state party shall consider establishing, in accordance with RSD its domestic law, effective financial disclosure systems for appropriate public officials and shall provide for appropriate sanctions for non-compliance. Each state party shall also consider taking such measures as may be necessary to permit its competent authorities to share that information with the competent authorities in other states' parties when necessary to investigate, claim and recover proceeds of offenses established in accordance with this convention. 6. Each state party shall consider taking such measures as may be necessary, in accordance with its domestic law, to require appropriate public officials having an interest in or signature or other authority over a financial account in a foreign country to report that relationship to appropriate authorities and to maintain appropriate records related to such accounts. Such measures shall also provide for appropriate sanctions for non-compliance.
Article 53. Measures for direct recovery of property. Each state party shall, in accordance with its domestic law, a. take such measures as may be necessary to permit another state party to initiate civil action in its courts to establish title to or ownership of property acquired to commission an offense established in accordance with this convention. b. take such measures as may be necessary to permit its courts to order those who have committed offenses established in accordance with this convention to pay compensation or damages to another state party that has been harmed by such offenses. And c. takes such measures as may be necessary to permit its courts or competent authorities, when having to decide on confiscation, to recognize another state party's claim as a legitimate owner of property acquired through the commission of an offense established in accordance with this convention. Article 54. Mechanisms for recovery of property through international cooperation in confiscation. 1. Each state party, in order to provide mutual legal assistance pursuant to Article 55 of this convention with respect to property acquired through or involved in the commission of an offense established in accordance with this convention, shall, in accordance with its domestic law, a. take such measures as may be necessary to permit its competent authorities to give effect to an order of confiscation issued by a court of another state party. B. Take such measures as may be necessary to permit its competent authorities, where they have jurisdiction, to order the confiscation of such property of foreign origin by adjudication of an offense of money laundering or such other offense as may be within its jurisdiction, or by other procedures authorized under its domestic law. And C. Consider taking such measures as may be necessary to allow confiscation of such property without a criminal conviction in cases in which the offender cannot be prosecuted by reason of death, flight, or absence, or in other appropriate cases. 2. Each state party, in order to provide mutual legal assistance upon a request made pursuant to paragraph 2 of Article 55 of this convention, shall, in accordance with its domestic law, a. take such measures as may be necessary to permit its competent authorities to freeze or seize property upon a freezing or seizure order issued by a court or competent authority of a requesting state party that provides a reasonable basis for the requested state party to believe that there are sufficient grounds for taking such actions, and that the property will eventually be subject to an order of confiscation for purposes of paragraph 1a of this article. B. Take such measures as may be necessary to permit its competent authorities to freeze or seize property upon a request that provides a reasonable basis for the requested state party to believe that there are sufficient grounds for taking such actions, and that the property would eventually be subject to an ucalo order of confiscation for purposes of paragraph 1a of this article. And Otate C. Consider taking additional measures to permit its competent authorities to preserve property for confiscation, such as on the basis of a foreign arrest or criminal charge related to the acquisition of such property. Article 55. International cooperation for purposes of confiscation. A state party that has received a request from another state party having jurisdiction over an offense established in accordance with this convention for confiscation of proceeds of crime, property, equipment, or other instrumentalities referred to in Article 31, paragraph 1 of this convention situated in its territory shall, to the greatest extent possible within its domestic legal system, a. submit the request to its competent authorities for the purpose of obtaining an order of confiscation and, if such an order is granted, give effect to it, or b. submit to its competent authorities, with a view to giving effect to the extent requested, an order of confiscation issued by a court in the territory of the requesting state party in accordance with Articles 31, paragraph 1, and 54, paragraph 1a, of this convention insofar as it relates to proceeds of crime, property, equipment, or other instrumentalities referred to in Article 31, paragraph 1, situated in the territory of the requested state party. 2. Following a request made by another state party having jurisdiction over an offense established in accordance with this convention, the requested state party shall take measures to identify, trace and freeze, or seize proceeds of crime, property, equipment, or other instrumentalities referred to in Article 31, paragraph 1 of this convention for the purpose of eventual confiscation to be ordered either by the requesting state party or, pursuant to a request under paragraph 1 of this article, by the requested state party. 3. The provisions of Article 46 of this convention are applicable mutatis mutandis to this article, in addition to the information specified in Article 46, paragraph 15, Requests made pursuant to this article shall contain A. In the case of requests pertaining to paragraph 1A of this article, a description of the property to be confiscated, including, to the extent possible, the location and, where relevant, the estimated value of the property and a statement of the facts relied upon by the requesting state party sufficient to enable the requested state party to seek the order under its domestic law. B. In the case of a request pertaining to paragraph 1B of this article, a legally admissible copy of an order of confiscation upon which the request is based issued by the requesting state party, a statement of the facts and information as to the extent to which execution of the order is requested, a statement specifying the measures taken by the requesting state party to provide adequate notification to bona fide third parties, and to ensure due process, and a statement that the confiscation order is final. C. In the case of a request pertaining to paragraph 2 of this article, a statement of the fact relied upon by the requesting state party, and a description of the actions requested, and, where available, a legally admissible copy of an order on which the request is based. 4. The decisions or actions provided for in paragraphs 1 and 2 of this article shall be taken by the requested state party in accordance with and subject to the provisions of its domestic law and its procedural rules or any bilateral or multilateral agreement or arrangement to which it may be bound in relation to the requesting state party. 5. Each state party shall furnish copies of its laws and regulations that give effect to this article and of any subsequent changes to such laws and regulations or a description thereof to the Secretary-General of the United Nations. 6. If a state party elects to make the taking of the measures referred to in paragraphs I and II of this article conditional on the existence of a relevant treaty, that state party shall consider this convention the necessary and sufficient treaty basis. 7. Cooperation under this article may also be refused or provisional measures lifted if the requested state party does not receive sufficient and timely evidence or if the property is of a de minimis value. 8. Before lifting any provisional measure taken pursuant to this article, the requested state party shall, wherever possible, give the requesting state party an opportunity to present its reasons in favor of continuing the measure. 9. The provisions of this article shall not be construed as prejudicing the rights of bona fide third parties.